Hello, and welcome to today's episode of Community First podcast, where we have social and legal discussions of issues affecting the community. This is a podcast proudly brought to you by BMP Associates. On today's episode, we'll be addressing private M&A due diligence. So, if you're looking to acquire a company or merge with another company, what do you need to know in conducting your due diligence? These are the questions and more that we'll be addressing in this episode. Now, I'll briefly introduce our guest for today. It gives me so much pleasure to introduce her. So, our guest for today is a dual qualified lawyer. She specializes in corporate and commercial transactions and has experience in practice in Nigeria, in Ghana, in the UK, in Ireland. Talk about a very experienced lawyer. And she specializes in M&A transactions. So if I were you, I'll hold on to her every word when it comes to due diligence in private M&As. Today we are pleased to welcome Abisola Odunayo to help us address this issue of private M&A due diligence. Welcome, Abisola.
Thank you for that introduction, Michelle. Thank you. It's a pleasure to be here today. Thank you. So let's get right into it.
Yes. So we're going to take this step by step. I would want to find out, could you give us a brief introduction about mergers and acquisition for those who may not have heard of it so that there's some context?
Okay, so good question. When we say mergers and acquisition, which is commonly called M&A, it simply means it's a form of business transaction, first of all. And when we say merger, it means the consolidation of two or more companies coming together as one. And when we say acquisition, it simply means a company acquiring another entity. So, as a form of business transaction, this is used together and then it's called M&A. In this type of business transaction, there are a lot of reasons why people conduct or undertake M&As, and one of the reasons could be that the company is looking to grow. It could also be that the company is looking to gain a competitive advantage in the markets. The company could also be looking to access new technology or expertise that the other entity, which is mostly called target entity, has. So there are different reasons. The company could also be looking to diversify too. So there are different reasons as to why companies embark on M&A. And I'm hoping to take you through the due diligence that is usually conducted when parties or entities want to undertake or start any form of M&A transaction.
Okay. Glad you've already introduced the topic. So could you tell us a bit about due diligence and what role it has to play in this whole mergers and acquisition process?
Okay, so from the term due diligence, it's simply investigation, let me put it. So, what I'll try to also do here to the people that are listening, to our listeners out there, is I'll try as much as possible to simplify and not use a lot of legal terms that could be confusing.
Have
So,
their head spinning around.
starting with what due diligence means, it simply means investigation. Investigation about a person or investigation about a business. So for every M&A transaction, one of the initial steps that you take, in fact, the initial step that you have to take is due diligence. So you audit the business of the company you seek to acquire or you seek to merge. Now, like I mentioned, when it comes to due diligence, you're basically auditing the business of the target entity. You're looking at their legal operations, you're looking at their commercial operations, you're looking at the financials of the company, you're simply looking at the DNA of the company. What exactly makes this company? What forms this company? What are the assets of this company? So you need to investigate before you make a commitment. So it's a very, very important and crucial process, as that sometimes could affect the purchase value of such target entity. So based on the outcome of the due diligence, it also has a way of affecting the value that could be offered to also purchase the target entity.
Okay, so my next question was going to be about why we should conduct due diligence, but I think you started talking about that when you address the fact that it can influence the value and all that. Do you have any
Yes.
other reasons you'd
Oh,
want to?
yes. So, in terms of the importance or reasons for conducting due diligence, first, the major reason would range from you identifying the risk involved in this
Mm,
entity you're about to purchase or the entity you're about to merge with. You need to know the risk within that industry. You need to know more about the seller, which is the target entity. What exactly is their business operations like? What do they have? What are their assets and what are their liabilities? You'd also need to know the value that you'd want to place on this company, which is something that is very key because you're parting away with money. You need to also identify the steps that are necessary to integrate this business with yours, or in terms of steps that are necessary in terms of the acquisition or the merger. You need to understand that whoever is also selling their business, you need to know that they have good title to the assets or to the shares that would be acquired. So it's a key step, or one of the importance is that it helps you when negotiating from the seller's perspective and also from the buyer's perspective. Both sides are able to negotiate effectively when a good due diligence has been conducted because each party literally knows where they stand.
okay, so that's good that you've given us a number of reasons why we should conduct due diligence. One of the biggest headaches in such a transaction that I have experienced is getting the clients to actually understand why they need due diligence, because they see it as, oh, I've already discussed with the person and we have a good relationship going on. So all this due diligence is going to waste time. But I mean, if you know that doing actually conducting proper due diligence can actually maybe drive your price down or let you know what you're getting into, then it's a good business decision, I guess.
So I just wanted to add that as I've been speaking, I mentioned that it determines whether or not the buyer would even want to proceed with the transaction. And in some rare cases, at the end of a due diligence, the buyer may want to back out. So that's why it's very important. By the time you investigate the target company, you realize that, okay, maybe this company is actually not worth the stress or
Right.
worth what they are offering in the first place, or um, things are not in order when it comes to dealing with this company. So I would rather just keep my money and then shop around for any other company that probably aligns with the interest or the things that I'm looking out for in the company I want to acquire.
Yeah, well said. Thank you for talking to us about the reasons why you have to conduct due diligence. Now, the next thing I would like us to address is, okay, the buyer has taken the decision, interested in conducting due diligence on the seller. In terms of preparations as a seller, what goes into the pre due diligence preparation?
Okay, so the seller has a lot of work to do when it comes to pre due diligence preparation, as it's the target entity that is being bought. A serious seller is expected to have conducted its own internal due diligence pre sale. So you need to already look into your business operations and then identify the risk involved, the deficiencies, any form of liability you may have outstanding as a seller. And
Mhm.
when you conduct this pre due diligence, it enables you to mitigate against any form of risk that is involved before the transaction. Like I mentioned earlier, the outcome of a due diligence could significantly impact the purchase value of the target company. So, as a seller, if you would want things to work in your favor, one of the things you have to do is to ensure that your house is in order. In addition to that, before any due diligence really starts, both parties would most likely have head of terms or letter of intent that sets out the key details of the transaction as it relates to the purchase value, as it relates to any warranties that the buyer may be expecting, any form of price adjustments, indemnities, and all of that. So
Yeah.
when you have this before the due diligence, it also gives both parties an idea of what to expect before any form of due diligence is conducted. And based on negotiation between the buyer and seller, the seller also has an idea of what the buyer is expecting. So basically, you need to ensure that your house is in order before any due diligence is conducted as a buyer or
Okay.
as a seller rather.
Okay, thank you for that, Abisola. So I'm glad you spoke about the head of terms. I would want you to touch on how to identify the scope of the due diligence process.
Okay, so I would say that the scope of a due diligence process really depends on a lot of factors. So the due diligence that would be conducted or undertaken for a company with a purchase value of less than £1 million would be different from the due diligence that would be conducted when you're seeking to acquire a company that is valued over hundreds of millions. Now, I'm not saying that a thorough work would not be done in both scenarios, but the value of the transaction sometimes would determine like what is expected. A bigger transaction most times involves a wider scope. So we're looking at the parties involved, we're looking at the type of business and the industry. These are like some of the factors that affect the type of due diligence that will be conducted. So it gives you area of concentration. The industry is very key. The type of due diligence that you'll be conducting in an industry that is largely based on tech would be different from the type of due diligence you'll be conducting for an hospitality management company. You're looking at the structure of the company. You're looking at whether it's solely a share sale or an asset sale. You're looking at the value of the transaction, as I mentioned earlier. You're looking at the cost involved. You're looking at the time. Some companies are pressed for time. Like they want to conclude the transaction before a certain duration, maybe because they're about to raise and there's like another funding round coming up, and then they need to close on the transaction before the next funding round. You're looking at the risk tolerance of the buyer. Now, some buyers they don't really have like the high risk tolerance, so they are willing to even proceed and just do the very basic or minimal due diligence the seller if the seller is willing to sell at a very good price. They may want to like, you know what, let us skip all the long process and then just get right into it. So the type of due
That's if they
diligence
have
for
a high
such
risk
transaction,
tolerance, right?
yes. The type of due diligence for such transaction may not be as thorough as some, depending on your high risk tolerance. So, like I mentioned, the industry is very important because you may need to engage specialist advisors when it comes to due diligence in some types of industry to ensure that the right things are covered. So maybe it could be as it relates to environmental, it could be as it relates to tax, like different things, depending on the industry, depending on the nature of business. These are the things that actually affect the scope of a due diligence. Now, irrespective of the industry, the business, the advisors, and all of that, the key things that you're looking at when it comes to a due diligence as relates to the scope are the red flags. So, what are the red flags before I purchase this company? Now, when it also comes to the red flags, you need to also know the risk appetite of the buyer. For some buyers, some things may not be a major deal breaker for them, but for some buyers, those things may be key. Could be as it relates to their intellectual property. For a buyer, and depending on the industry, IP may be key. So you need to look at the red flags during the due diligence process. So basically, the parties, the size, the industry, these all affect the scope of the due diligence that would be undertaken.
Okay. So, how do you practically go about assessing all these things? So, the risk tolerance of the buyer and all these things that you've stated, practically, as from your perspective or in your experience as a lawyer, how do you go about assessing all that?
So, in terms of conducting this process, I would like to start from the seller's perspective and also the buyer's perspective, as there are some best practices that are recommended for each party. When it comes for to the seller, like the seller needs to prepare, and like I earlier said, you need to ensure that your house is in order, because anyone coming would definitely want to do a thorough investigation before parting away with any money. So you need to start by identifying the potential issues that may come up even before the due diligence starts proper. You need to also look at the industry regulators. Now, the industry that I'm operating within as a seller, are there any consents or approval I may require? And this is very key because this could actually delay the transaction. There's no point proceeding with the transaction if you are aware that the relevant authorities that would approve this transaction would not give the approval. So at the onset, these are the things you as a seller may also need to investigate about. And even the seller on their part, the buyer rather, would also do their own investigation to see, okay, what are the things that are needed in this industry that I'm going to? What are the relevant consents that may be required? In terms of also preparing from the seller's angle, when you prepare well, it helps you to streamline the things that are key and the things that you should focus on, and could give you a stronger bargaining power. The seller is also expected to have a good corporate governance. You have to ensure that you have all the records. You should have the necessary records to back up whatever thing or whatever issue that the buyer may raise. And then more importantly, you're also looking at setting up a data room. This is where all the documents would be uploaded from the seller as it relates to whatever inquiry that the buyer seeks. So one key thing that the seller would have to do definitely is to set up a data room. And it's not just about also setting up a data room, you need to ensure that the right documents are uploaded, the key documents are uploaded. You're not holding anything back in terms of material details that needs to be disclosed to the buyer. Now, when it comes to the buyer, in terms of preparation for success as to what is required during the due diligence stages, right? You need to engage expert advisors, get good team of lawyers, a good team of financial advisors that would advise you appropriately in terms of the next step to take when issues come up. How are you supposed to address it? You should also discuss the scope of the due diligence with your advisors, and you should be willing to also hear from your advisors what they have to say. So, like I mentioned earlier, the risk appetite of buyers differ. So, some buyers will let you know what their deal breakers are. and what their red flags would be should we see these things in the process of investigating, doing the due diligence process.
Yeah.
And you're also looking at the buyer's, the target's reputation, rather, the seller's reputation in the industry. Is there any bad reputation? And it's expected as a buyer that you would have also conducted your public search about the seller. So the due diligence stage obviously would not be the first time you're just communicating or meeting with the seller. Before you even approach the seller, it's
Should have done your preliminary inquiries.
in your preliminary inquiries. You'd have gone to do your public search. Depending on the country you are, you can either go to the company's house if you're in UK, or in Ireland, you go to the CRO, in Ghana, office of the Register General in Nigeria. Like, depending on, obviously, each country has a public data system where you could search about companies, you could search about the directors, you could even search about the beneficial owners to be sure that this is not these are not members of companies that have been blacklisted in some other countries. So you also need to conduct your own due diligence on the buyer. So these are like the major things that needs to be done as it relates to the preparation stage. But as it relates to the due diligence proper, it's the main task is on the buyer's team, because they are the ones that would be carrying out the investigation. But on the seller's part, they need to put their house in order so that when the buyer's team starts to carry out their investigation, they are able to see the appropriate things that they are looking for.
Yeah. Okay. Thank you. This has been very insightful. Can you let us know what goes into the conducting of a due diligence process in detail? You know, from the perspective and your experience and all that, the practical things we need to know as lawyers, as buyers, as sellers, all the parties. Let us know. Give us the 411 on what goes into it.
Okay. Good question. So there are different ways that parties conduct their due diligence. Different ways, different methods, but the most commonly used method is that the buyer's solicitors would prepare a due diligence questionnaire. So this due diligence questionnaire is going to highlight the key things that the buyer is looking for in the target company as it relates to investigation. Now, this due diligence questionnaire deals with a whole lot of things, like a whole lot of things, such that when the questionnaire is answered, it gives the buyer an informed decision as to whether or not, or an informed idea as to whether or not they would like to proceed with the acquisition or merging with the target company. Now, I'm going to take us through some key areas that as solicitors we look out for when conducting a due diligence exercise. So, like I
Please,
mentioned,
before you go into it, please let me just tell our viewers these are things that people pay for, pay to know, billable hours. So please, you're getting it here. So
okay.
stick with us.
Okay, thank you, Michelle. So, first thing that you'd be looking at is the corporate structure of the target entity. Like I explained earlier, the target entity is the seller. You need to understand what the corporate structure is. So, you're looking at things about the incorporation details of the company. You're looking at the details of the director. Does the company have a company secretary? Who's the company secretary? Does the company have a subsidiary? The constitutional documents of the company, the statutory books, the annual returns, have they been filed up to date? These are really key because the corporate structure gives you an idea as to what the company is about on a surface level. Then we
And who you are
now
dealing with, right?
exactly. Then we now move on to the share capital of the company. Who are the shareholders of the company? Who owns this company? Do they have any form of beneficial owners. So you need to look at the legal and the beneficial owners of the company. What are the class of shares? Are there any specific rights or restrictions attached to the shares in this company? What is there any form of preemption rights? This is very important when it comes to a share sale. You need to know everything you're buying, especially when the shares of the company are involved and then assets too are involved. Because sometimes when it comes to acquisition, which I'm not sure I mentioned earlier, acquisition can be acquisition of the entire shares of the company, or it could also be asset acquisition or a combination of both shares and assets. Although, yes, shares are assets, but when it comes to asset acquisition, sometimes shares may be excluded, and we're just looking at the tangible and intangible assets of the company. So, depending on the structure or what you aim to achieve, you need to know who the legal and beneficial owners are. Now, is there any form of shareholders agreements relating to the relationship between the shareholders and the company? You also need to know about that, because there are some terms that would be triggered once the company once the company is to be acquired by third parties. The agreements may make reference to some conditions that must be met before such acquisition or merger could take place. Then, importantly, you need to look at the finance and the accounts. That is very, very important. Sometimes, like I said, people buy companies because they probably want to diversify or they want to grow. You'd also want to buy a company that you know should be profitable based on your estimate or your valuation. So it is very important to know the details as it relates to the finance and the account. You also need to look, does the company have any form of credit facilities? Have they been paid? Are they outstanding? Was the company or has the company obtained any form of financial assistance or grants? Now, this is very important because there are some grants that have some conditions attached to them in the event of the company sale. Some grants may require that if a sale of the target company occurs within maybe 3 years or 5 years after the grant of financial assistance, then such grants may have to be refunded back to the entity. So those areas are key. And like I said, it could affect the purchase price, because if there would be any refund going back to a third party entity or a government or a government agency and all of that, that could also affect the purchase price that the seller would be receiving, because they would have to part away with some form of money. So you need to look at the bank account details. Would there be any adverse change in the financial position of the company upon this acquisition that we're about to embark on? You need to look at it. And sometimes when it comes to accounts, you're looking as far back as 3 years, 5 years, depending on the duration. Another
So I guess
important
this is
aspect
why
that
you
is
need
key
a
when
team
conducting.
that, sorry, I was saying that I guess this is why you
Yeah, no, go
need
ahead.
a team that has is a most multifaceted team. It's not a one man
Exactly.
show.
Exactly.
Exactly. If you need to
Exactly.
bring in
So on our
experts
part
to
as
assess these things.
Yes, on our part as lawyers, we, for example, would review the credit facilities, whatever agreements you have with your creditors, if any. When you have your financial advisors on board, they are looking at the accounts. They are going into details as to what the account is, which this may be beyond the scope that the solicitors have been engaged for. Now, the next one that we would look at, which is also very key in the due diligence investigation that is being conducted on target company, are the contracts. You need to know the key contracts that the target company is a party to. Now, when we're looking at contracts, one of the things that the seller can do to make this easy for the buyer is, because the buyer obviously enters into a lot of contracts every day, when we ask you to send us copies of all contracts that you're a party to, or material contracts that you're a party to as a seller, you're not just sending us every contract that you've entered. Rather, it has to be material to the transaction or contracts that are key to your company. You're not sending us contracts between yourself and probably maybe someone who comes to who performs services that are probably one off or not consequential or substantial enough. So we need to look at key contracts. For example, customers with your key customers. These are the main people that bring money in for the target company. You need to look at customers, contracts with those customers. You need to look at contracts that detail that relates to maybe any form of services where commission is being paid. Contracts that have not been on arm's length basis, you need to also look at that, or contracts with connected persons with the target entity. And when you're looking at those key contracts, as lawyers, we're looking at change of control clauses. We're looking at any form of restriction when it comes to assignments or when it comes to change of control. Sometimes a sale of a company could actually trigger an event of default. So you need to look at those contracts to see if there is any contracts within the target entity that could materially affect this acquisition we're about to embark on. So that if there is any form of contract of such nature, then this is where the seller would also need to obviously notify their customers or whoever the client is about the proposed acquisition, so that it doesn't in a way like affect whatever merger or acquisition that will take place. You'd also look at loan agreements. You need to look at all the relevant clauses within the loan agreement just to ensure in general that no form of event of default is triggered and it would not materially impact the transaction sought to be undertaken. Then you also need to look at the assets of the company. Every company would have their assets, and that's one of the reasons why a buyer would even be interested in buying the target company. You need to look at what the assets are. Who owns these assets? Now, a lot of companies would have assets that they own, and they would also have assets that they sometimes share with others, assets that are leased, assets that are licensed. There are different types of assets, both tangible and intangible. You need to look at details of those assets that the company has, and then you need to look at if there is any rates involved, any expense involved in terms of maybe annual maintenance of those assets. If there is any cost involved in the maintenance of those assets, you also need to look at it. If there is even any clause involved relating to change of control, you need to look at it. Then you look at intellectual property rights, very key. If this is, for example, an IT based company, IP is quite key for them.
Yeah.
Even a lot of companies now, obviously, are looking at intellectual property. You need to protect your IP, and from your IP, we're aware that you can make a lot of money from your IP, from the company's goodwill and all of that. So you're looking at, okay, what are the tangible, what are the sorry, what are the intangible assets of the company as it relates to their IP? Do you have IPs that you own? Do you have IP that you've leased out to third parties? Do you have IP from third parties that you as a target entity, you're having to pay a certain cost for? What are the
Essence.
arrangements you have with this third party that you've leased out IPs to, or they've leased out their IPs to you? What are the annual costs of maintenance of this IP? Do you have IPs that are unregistered? What are the evidence of your registered IP? So most of these informations, you include them in this questionnaire, and then the buyer obviously updates in terms of answering the questions and then providing documents to evidence whatever it is that they've answered. Then you're looking at the IT system. For an IT for a company that is heavily reliant on IT systems, like the tech companies, for example, you're looking at, okay, how are your IT systems operated or used? What's your software, your hardware, the database? What do you have in place? What are the things that you're leasing? What are the things that you've licensed? What are the documents or the service level agreements that you have with third-party providers? What are the maintenance agreements that you have with third-party providers? Is there any software that is developed in-house, or is there any software that is subject to another third party? You also need to look at data protection and privacy. Like, that is very key now in this day and age. It's expected that the company should have its data privacy policy. How are personal data being processed within the company? Compliance with GDPR, details of any form of security breach leading to unauthorized disclosure of data. You also need to look at details of any complaints that may have been received. Now, this is very, very crucial, because if there is any form of breach, what this means is that if the buyer is not aware and then they acquire this target company, they may be liable for things that they were not aware of, which is where obviously disclosure letter comes in, but that's for another day. But basically, as a buyer, you want to be aware of the liability that you're also buying alongside the assets. And
So you
that's
can
why.
make an informed decision, right?
Exactly. And so that's why you also need to know if there's been any breach, because we know of a lot of fines now that are being issued against companies that have breached GDPR. So you really need to know if there's been any breach, if there's been any complaints, how it was addressed. Now, before you also buy any entity, you need to know, as is the company involved in any form of proceedings, whether litigation, arbitration, or mediation, whatever dispute proceeding, is the company a party to? Are they likely to be a party to? Has something happened, or have they breached terms of agreements that could lead to any form of suit being instituted against the company? We also need to know this, and then it's expected of the seller to give us this information. You also need to know about the employment details, like who are your employees. Like, it's a thorough process. It's not, due diligence is not something you would.
Some serious detective work.
Yes, like I said, and that's why the right term to use is investigation, because
Yeah.
that's what detectives do. They investigate. We need to know the DNA, what forms this company. We need to know everything about the company. So you also need to know about the employees of the company. What are like, how many employees do they have? And it's not just about the employees. You need to know their terms of employment contract. So rather than sending us the terms of everyone's employment contract, the company would most likely have like a template for all employees. So you can send the template for the buyers, solicitors to review. You need to know, does the company have part-time employees? Are there any employees that are currently on maternity leave? Are there any employees that their employment was terminated maybe in the last 6 months? Is there any employee on sick leave? What are the pension scheme? What are the rights and benefits? Is there any employee share scheme? Your internal policy, the disciplinary procedures. Do any of your employees work outside the jurisdiction within which the target company is located? Because that could trigger tax issues. That could trigger whether the necessary work permits have been sought, or if you have foreign employees working with you, are there any collective bargaining agreements? What are the medical or life insurance involved? Because a company, like a buyer acquiring a target company, may or may not take on the employees on board. So helping them to make an informed decision as to whether or not they want to. These are some of the things they look at. Are we downsizing the employees, or we're fine with the number of employees? Now, what are the things, like the rights, the benefits? So they need to know, okay, are we capable of taking this on upon acquisition? So these are, like, obviously some of the reasons why you need to get clear details about the employment situation within the target company. Then you're also looking at the regulatory aspects now, and this is to ensure or avoid any form of anti-competition within the industry. Do we need any form of consent? Um, license? Do we need any form of approval? Because we have some anti-competition regulatory bodies to ensure that
Mm.
whatever acquisition or merger that is going on is not something that should cause a form of negative, not a negative kind of acquisition within an industry, because when you try to stiffen competition, then it's going to affect the consumers. So you also need to look at the regulatory aspects when it comes to any form of merger or acquisition. Then this would also relate to tax, as it relates to tax due diligence, which the buyer is also expected to have gotten their financial advisors or accountants to advise them on. So let's look at the tax obligations. Have the company been paying their tax adequately? You find out that you're acquiring some companies, and then their tax matters is far from the best. So in terms of payments. So you have maybe a couple, they own a company together, but as it relates to how they've been paying themselves, things may not have been done appropriately, such
Yeah.
that also affects their tax obligations, which they have not complied with. So tax is so important when it comes to the acquisition of a company or merger. It's extremely important because the buyer could be acquiring a company that has a huge tax liability that they might have to pay for. So it is very, very important. And one of the ways to protect yourself as a buyer when a company is exposed to like huge tax liability, or not even exposed, but just to protect yourself, is by entering into a tax deed with the seller. And what the tax deed basically does is that it ensures that should there be any tax liability, then the seller would be required to indemnify the buyer, like tax
Yeah.
liability that probably arose before completion of the transaction. So tax is very, very important. I would not advise anyone to joke with it, and it's always important that you comply with your tax obligations to avoid um, penalties that could have been avoided. And then sometimes we could also consider environmental due diligence. And like I stated earlier, the industry that um, the target operates within determines the type of due diligence that will be conducted. So, for example, for a manufacturing industry, there may be some environmental obligations on them that they need to comply with. And for whoever would be buying such company, you need to ensure that whatever obligations as it relates to health and safety, environmental damages that may have occurred, or regulatory enforcement, or if there's been any complaint, you also need to know about it so that you understand what you're buying. Basically, you understand how the target company operates, and you've done your thorough investigation. So these things that we look out for as it relates to investigations, these and more are usually contained in the questionnaire, which is quite like long. Like it's a document that has a lot of questions, yeah. And then it's expected that the buyer takes their time, sorry, the seller rather, time with its own team also look through the questions that have been sent, and then obviously answer these questions and then support them with the relevant documents when necessary. And then that brings us back to what we discussed initially, which is when a seller is also preparing. That's why the seller needs to conduct its own internal due diligence pre-sale, because the buyer rather, would definitely come for everything. They are asking all the relevant questions because they just don't want to be buying liabilities. And that's why it's important that the seller from the onset has also done its own due diligence pre-sale, so that when the buyer comes with this question, they are more than ready to tackle whatever issue that may arise from the questions that have been sent.
Okay. Thank you, Abisola. So I'm going to take you back to your point about the environmental um, questions that you need to ask and due diligence you need to conduct. Do you find that in recent times, companies
ESG.
want to, yes, include ESG in their due diligence? And as a lawyer, how do you incorporate that? How do you reflect that? What are you looking out for when it comes to ESG?
Okay, so I tried not to go into that, although that came to mind. But
And then I caught you.
also very conscious of time. So yes, like I mentioned, depending on the industry. Unfortunately, though, not every company has good ESG practice in place, unfortunately. But some industries, and depending on the country that you are now, with what is happening around the world as it relates to ESG, a lot of some other companies are now making intentional efforts to ensure that, okay, we have our ESG policy. What are we doing to contribute, or what are we doing to reduce the impact of what we are doing as a business towards our community, whatever way we could do it. So some companies, and if you remember what I said, we need to look at the scope of the due diligence and what is a deal breaker for whoever is buying the company. For someone buying a tech company, the issue of ESG may not be so substantial for them, for a tech company, depending also on how big the tech company is or their presence globally. Now, when it comes to a manufacturing company or a company within the aviation space, these are key issues that they may consider. A company within like the educational space may not have some like the relevant ESG structure or policy in place. Now the question is this a big a deal breaker rather for the buyer? If it isn't, that's fine. If it's not, what happens is you have list of the questions relating to ESG as it relates to your policies. Have there been any breach? Have there been any complaints? Is there anything that you've done like internally? What are you doing to mitigate your impact within the society and all of that? So when asking these questions from the buyer's solicitors, what happens is if you don't have any of these things, you disclose we don't have it. You don't need to lie about it. You have to
Honesty is the best policy.
and transparent about it. And this helps the buyer to make an informed decision. Like I mentioned, is this a deal breaker for the buyer in buying the company? Unlike some other companies where it would be expected for you to have this in place. So, like I mentioned, it's about the scope of the due diligence. What are the major red flags? And then what's the deal breaker for the buying entity? If ESG is a deal breaker for the buying entity, then definitely that's a red flag. And then based on the disclosure, the buying entity could make their informed decision as to whether or not they would like to proceed. And if they still want to proceed, then that's where the issue of liabilities, that's where the issue of adjustment of purchase price also comes in, because it means that I am going to be buying a liability that you've not covered. And doing that, it would cost me something because I would now have to comply with these things you failed to comply with, which may also bring about some financial impact or financial consequence for the buying entity. So let's say, for example, the purchase price would have been 10 million pounds. We can look at, okay, what would be the estimate of liability for your non-compliance with ESG based on the regulatory requirements. If the fine or there's a penalty applicable that would be worth, let's say, 2 million pounds, then this could now reflect in the purchase value of what you would be giving back to the seller.
Okay, thank you very much. So we're going to move on to, so we've run through the process. Now, after we've conducted our due diligence, what are the key considerations that come into play? So
Okay.
post due diligence.
So once the investigation is complete, what is expected is a due diligence report, which is what we lawyers would also have to prepare. So based on all the regulatory, environmental, financial, share structure, all the questions that we've asked basically in the questionnaire, we review the answers given, we review the documents provided, look at whatever red flags that we may notice, and then we use that to prepare a due diligence report. Now, once this due diligence report is prepared, it's expected that the red flags will be highlighted to the buyer so they know the risk involved and the liabilities. We draw that to the attention of the buyer. And then with this report, the buyer is able to assess the transaction and then make a decision as to whether or not they would like to proceed with the transaction. This also helps the buyer to then negotiate some terms, probably maybe based on non-compliance. They are able to negotiate some terms based on the reports that has been prepared. So a lot of the post due diligence consideration deals with the reports, which helps the buyer to make an informed decision. And then that also helps with some condition precedents and condition subsequent that you may have. So, based on the review of the reports, the buyer could then say, okay, considering that the seller does not have this or that, we could say that before this transaction progress, then you need to ensure that you have done this, you've done that, and then those sum up to the condition precedents that you have before the transaction can close.
Okay. So as an acquiring company, how do we integrate the target company to ensure the smooth transition?
So, in terms of integration, you need to look at again the industry, and then you need to look at the management. So, a buyer may already have the relevant expertise when acquiring a target entity. Probably they are already within the same industry, so they understand the process and how things work. And for example, when we spoke about the reasons for M&A, one of the reasons is to gain competitive advantage. So if you're acquiring an entity that is already doing what you do in terms of similarity as to your business process and all of that, the transition process would likely be smooth. But if you're acquiring an entity that is quite distinct or different from what you do, or even sometimes similar, then you can now consider things like a transitional services agreement. So what that does is aside the share purchase agreement or the disclosure letter or the tax deed and all those documents that you may have a transitional services agreement in place that helps to ensure that even after the purchase, the seller, the key management of the seller, or the key staff of the seller, depending on the arrangements, they stay back to ensure that the buyer has a smooth transition. So basically, they stay back to train, to teach, to assist the buyer wherever they may need help. So it's not going to be like a full-time employee arrangement. It could be uh you could have like a service agreement or like an independent contractor agreement, but definitely not an employee employer relationship agreement, unless of course the buyer is willing to do that and also pay for that. But usually you would have the key management enter into an agreement with the buyer to ensure that there's a smooth transition, just to assist them and also help them during the process of finally easing into the target company. And the transitional period could be for a period of maybe 6 months or maybe 1 year, depending on the duration. Sometimes some consideration may be involved. Sometimes consideration could be in kind, depending on the arrangements between the parties.
Okay. So I'm glad you're talking about the transition. One question that I have, which is more of a practical experience, is that you've done your due diligence. Sometimes you even mentioned that some buyers may have a crunch time, which would not allow you to conduct as extensive a due diligence as you may like because of the crunch time. Now, are there certain measures as a buyer you can put in place in your agreement such that if after acquisition or after the merger, there are certain things that come up, you can reassess? If you could
Okay.
quickly touch on that. Yeah.
Okay, yeah, I will. In addressing that, I think maybe we should even discuss in general as to the kind of issues that would most likely spring up in this due diligence that's been conducted, and then how it is addressed in the contract in terms of the clauses and what you expect to see, like you just asked. So first, if we backtrack back to the due diligence report that I mentioned, the report would highlight the red flags that the buyer should be aware of. And an example of such red flags, which I have seen happen, would be maybe non-compliance with the relevant legislation, or you do not have the necessary approval, or you're not complying with a particular law of such nature. You could also have the regulatory issues, the antitrust or regulatory issues. Another key thing that we always see is a lot of contracts usually have clauses dealing with change of control. And then this change of control could trigger an event of default, or there could be restriction on assignment. So, in conducting due diligence investigation, we mentioned that you have to review key contracts. In some of the key contracts, the target probably has an agreement with their customer saying that this contract that we have together cannot be transferred to another party without our prior written consent. Sometimes the issue of including prior written consent may be silent, and sometimes we could say that in the event of any form of transfer, it could trigger an event of default. And this is because when dealing with a company, you would have done your investigation, so you're comfortable with who the owners of the companies are. The moment owners change, then you may not be comfortable with the new owners. And so that's why you have a lot of people inserting change of control clauses, assignment clauses. So they want to be sure that whoever you are signing this contract to, we are fine with them and they are capable of paying or fulfilling their obligations. Now, to curb this, or let's assume that some of these issues are flagged in the due diligence report, then what is expected is that the buyer would seek contractual protection from the sellers within the share purchase agreement, which we usually call the SPA, to ensure that they are protected from any of these liabilities or issues or red flags. And then this protection could come in form of indemnities and warranties. So you have clauses, you would definitely have like an indemnity clause that talks about the seller indemnifying the buyer against any loss, claim, actions, and things like that. You would have warranties too. You would have the condition precedent that I also mentioned. So there are some things that the seller may say, you know what, okay, we've identified this issue, but we think this is something that we could cure before completion of the transaction. And then as a result, there could be a condition precedent stating that the relevant waiver or the relevant approval should be obtained before completion of the transaction. We could even have parties entering into novation agreements for the new buyer that is coming on board. Then you could also have a price adjustment. That's another way of dealing with issues. If all every other thing fails, then the next thing is we need to go back to the price that has been proposed and then see how we can adjust it so that this would compensate me, if at all, for any form of liability. So I'm not having to pay as much as I would have because of these issues or the red flags that we've discovered in your company. And then I also mentioned the tax deeds. So if there's any form of tax liability, the buyer rather would require a tax deed to be entered so that the buyer can be protected from any form of tax liability. So it really, really depends. There are different ways. So depending on the issue or the red flags, that would determine how we can address a protection for the buyer in the contract or the relevant documents that will be entered between the parties.
Yeah. Okay. Thank you, Abisola. I feel like I've been to an M&A class. Yeah. So, would you want to say a few words as we conclude? Then I'll touch on my key
I
takeaways.
would say that, well, I've summarized due diligence within like how many minutes now? There's more to this, obviously. This is just like a brief summary in terms of the work that goes on to ensure a successful due diligence has been undertaken. Like it's really, really, really thorough. So I would say that for you to have a successful corporate merger or acquisition, parties obviously need to start with the scope. We need to be clear on the scope. We need to know what the red flags of the buyer would be, what would be the a deal breaker for the buyer. We also need to understand the risk involved in the target industry, and that would also help all parties know, okay, these are the things we should look out for because for this type of industry, these are the risks that are quite peculiar. And then you also need to have a good management of the acquisition of the merger process. That is very, very important. If not, you'd realize that a transaction that ought to be finalized within like 2 months has extended to like
That's,
6 months. Yeah. And then, most importantly, get a well equipped due diligence team. And due diligence process is not something you should hold back on when it comes to getting the best teams. Spend or use the necessary resources to acquire the right team for your acquisition or for your merger. Don't compromise on that. And there's a lot of work that goes into it. At the end of the day, the buyer solicitor does its best to ensure that the buyer is not just buying a liability that they are not aware of or buying, like Ghanaians would say, bad market. So you need to ensure that like a thorough job is done, and the only way you get a thorough job done is to have the well equipped team that is capable of managing the entire process.
okay. So for me, my key takeaways: use your resources to get the right team. Don't
Mhm.
skimp on that. Invest so that in the end you are not buying liabilities. That's
Yes.
one key thing. And also,
Yeah.
as a lawyer, it's important to know your capabilities and your scope so
Yes.
that you understand where you need external consultants and
Exactly.
you're humble enough to bring them on board so that the interest of your clients is best served. So,
Yes.
from all sides, I've learned something. Also, from the seller, you are looking at preparing before the entire process because your preparation is what makes or breaks the transaction. If you don't put in effort into preparing, then we start the due diligence process and it's we're asking you for documents and you don't have that and all that. You should actually engage lawyers to help you with your internal audit and your preparation process. Engage not just lawyers but the right team so that when the seller comes into the picture, it makes the transaction simpler.
Yeah.
So this has been a very, very exciting episode for me. I don't know about you, Abisola.
Oh yes, 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 yes. It has been, and I would just like to say few words
Go
before we.
ahead.
I would say that there's a Latin saying that says there's a Latin saying of caveat emptor, which is let the buyer beware,
Beware.
and this is applicable in not just your day-to-day transaction. It is even much more important when you're going into M&A transaction or you want to merge or acquire a company. So as a buyer, in as much as you're looking to profit or buy a new entity, whatever reason that may be behind the merger, or the acquisition, it is very, very, very important. And you should also know that as a buyer, you have the responsibility to conduct your due diligence before any purchase. It's about knowing what makes up the business, what the assets and what the liabilities are. And it's very important in any M&A transaction, and it would be almost a total failure, if I may say, if you don't embark on a due diligence process before parting away with your money in any M&A transaction. So caveats emptor.
Don't say we didn't warn you. She has said it all. All right, viewers. So this has been the Community First podcast. And as I said earlier, we have social and legal discussions on issues affecting the community. Today, we've touched on due diligence in M&A, which is a very relevant topic for our corporate commercial clients and people in business. I mean, generally, and I'm sure we are all affected by it one way or another, or we've all heard of it in one context or another. Today, I'd like to thank Abisola for her important and insightful contributions on this episode. We really appreciate it. Yeah. And we really hope that next time when we come for part two, which is beyond due diligence but actual M&A, you'll be willing to give us some of your time and grace us with your presence on our podcast so
Always
that
happy,
we can learn more and share more knowledge.
always happy
So,
to share knowledge.
so this has been the Community First podcast, and we look forward to having you on at the next episode. For now,
Thank you
bye
very much,
bye.
Michelle.
Thank
Thank
you.
you.